Morning, everybody. Today is March 17th, 2022, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong-Motan in the spring of 2020. Every Thursday morning, Jean Lawler and I are so happy to host a cutting-edge webinar on an exciting topic for mediators, arbitrators, and lawyers. As everyone knows, there's no charge for these great webinars. We ask you to contribute to a food bank if you like what you see. And one of our favorite parts of the webinar every week is to announce the running total of contributions of which we are aware so far by our wonderful audiences in honor of our fantastic speakers. So, as Natalie mentioned a minute ago, Jean, since it's St. Patrick's Day, let's talk about the green. If you'd give us the running total, please, that would be wonderful.
Well, we are doing great with green and turning it into food as a community. $253,332 is the number of donation, the amount of donations of which people have told us, and I'm sure it's much more, but that's, that's millions of meals. So thank you all.
What a fantastic show of generosity by our audiences in honor of the terrific people who've presented for us. We have another tremendous presenter today, Heather Rosing. Heather is one of California's most distinguished lawyers. She's Chief Executive Officer and President of Klinedinst PC, based in San Diego, with offices throughout California. And she's a top expert on legal and negotiation ethics. Heather has credentials more than we have time to mention. She's been president of so many organizations. Let's just mention here that she has served as the first president of the California Lawyers Association, which promotes professional advancement of California attorneys. After her tenure as CLA president concluded in 2019, she went on to launch the California Lawyers Foundation, an entity within the California Lawyers Association that is dedicated to promoting civics education, diversity, and access to justice across California. In addition, Heather Rosing also serves as president of the board of directors of the California Bar Foundation, which works to improve access to justice for underserved and underrepresented people throughout California. So distinguished. Heather, we're very happy to have you here talking about ethics with us. Please tell us a little bit about the food bank to which you would like people to direct contributions if they're in a position to do so. And then on with the presentation on Ethics 2022 to our friend Heather Rosing. The floor is yours.
Thank you so much, Jeff. I really appreciate it, and it's good to see you. It's an honor to present. I admire very much what you're doing here. That number is astounding, and I know that's only going to grow. So you're doing a great service to the ADR community and the legal community, and serving the food banks at the same time. Really tremendous. I'm asking you today to donate to the San Diego Food Bank. I'm in San Diego physically, though I practice across the state of California. And I've had various friends and colleagues who have been involved in the food bank. They deliver hundreds of thousands, millions of meals every year across San Diego County. So it's consistent with your mission, and I would, very much appreciate your donation today. So with that, I'm going to launch into my PowerPoint, and hopefully people can see that. If for some reason I'm accidentally sharing my email, please let me know that as well. I just have to say, the very first Zoom webinar I gave after COVID-19 hit, and I wasn't familiar with Zoom, none of us were, was for the San Diego Law Library. And I was supposed to screen share, and I just didn't know how to do it. My email popped up, and I'm like frantically hitting buttons, and it was comical. People thought it was funny, but we had to edit out my email out of the recording. So I know we've all had experiences like that, but I think I hopefully have this locked and loaded now to give you a clean presentation. So as Jeff said, my practice area is representing lawyers. I also represent judges, and I've been doing that for a number of years. Actually, Laura Frankel, who is on this webinar today, was the person who got me involved in representing judges across California. So I have a subspecialty in judicial ethics. I've also represented a number of arbitrators and mediators because that's kind of a subspecialty of both the attorney representation and the judicial representation. A lot of my work is litigation, defending people in these areas in litigation in state and federal courts. I do a lot of arbitration, but I also do just a ton of ethics advisement where we help people with ethical dilemmas and issues that may plague them. Again, lawyers, arbitrators, mediators, judges. I do a lot of state bar discipline defense. We represent judges before the Commission on Judicial Performance. So that's my background and what I can bring to you today. And I've been doing it for about 26 years. So my topic, as you can see here, is 8 cutting-edge ethics issues. This is a very popular presentation at this time of the year because a lot of people want to get the ethics credit. So I've given this presentation in different forms a couple of times, and I hope you find it interesting. I tried not to pick topics that are too mundane, that you've heard about 100 times, but topics that may not be on your radar screen, at least some of them, so that you get some new and fresh information for your repertoire of knowledge as you continue on with your professional activities. And I just want to say before we go into my next slide, if you have questions after this presentation, feel free to give me a call or shoot me an email. I'm always happy to talk with people, especially a crowd this distinguished, about any points in my presentation that I can expand upon for you. So feel free to reach out to me. I'm really easy to reach. You just Google Heather Rosing and a bunch of stuff pops up, including my email address. So the first topic today, we're going to go through 8 topics. So this is fast because we only have an hour. We'll be done by 9 a.m. at the latest. You know, the topic I picked first, I think, is about as cutting edge as it gets. I don't think it gets, you know, much more interesting than this. So this is the interplay of civility and ethics. So let me tell you exactly the background here. So civility in the profession of law has been a huge topic for decades. Lawyers, judges, ADR professionals across the state of California have, you know, touted and promoted the benefits of civility. There are civility codes everywhere. When I was president of the San Diego County Bar Association in 2008, my theme of the year was civility. And we had videos and happy hours, and we revised our code, and it was a lot of fun. More recently, however, there has been a movement to make civility more than just an aspirational goal, to put some teeth behind it, to make it, you know, more of a tangible concept. And accordingly, the California Lawyers Association, which Jeff mentioned, I'm the past president of, the California Judges Association and the State Bar of California came together to put together a civility task force. And we did this, I think, about a year and a half ago now, and it's chaired by Justice Brian Curry of the Court of Appeal, and I am the co-vice chair, along with Brandon Stallings from the State Bar of California. So what have we done? What is the work of this task force, and how does this relate to legal ethics? Well, let me tell you. So we compiled this esteemed panel or task force of judges and lawyers across the state. And we spent many a meeting talking about what we could actually do, again, that's tangible, concrete, to promote civility, because we believe it helps the profession, it helps the courts, it promotes access to justice, it helps the clients, it helps the individual lawyers with their mental health and well-being. And importantly, we think that civility has the effect of reducing bias against genders and people of color, people of different cultural backgrounds in our court system. Incivility oftentimes plays out in disproportional ways against these groups that I just mentioned. So that, you may not have thought of that, but that was one of our goals. So we came up with 4 recommendations, and I'm going to kind of go through them with you in a quick manner here, given our time constraints. But the first thing that we did is we came up with this idea that within your current CLE requirement, so not expanding it, but within it, you as a lawyer would be required to do 1 hour of civility training in your three-year period. You already are required to do some specialized hours, such as ethics, and this would be another specialized hour. We're really excited about this because we think that we can get some top speakers to put together some programs that will really stress, particularly to younger lawyers, why this, again, just isn't an aspiration to be civil and act with integrity in the practice of law, but why it's something that will really change your life and the life of your clients and help out our court system. We think that's probably going to sail through. You know, we don't know, of course, but where we are in the process right now, just so you know, is we issued a report on September 9th of last year. It's an excellent report that has a lot of attachments and addendums. And we secured endorsements of organizations across the state. And we have dozens of endorsements, and we're getting more. And on March 24th, Justice Curry and I are presenting to the State Bar of California, the Board of Trustees, and we're asking them to take action to implement some of these recommendations, because the task force in and of itself doesn't have implementation authority. We need an agency like the State Bar of California to do that for us. So March 24th is our next big date. So the second proposal that we have is that the Chief Justice, through CJUR, which is a judicial educational program, and other judicial educational programs, enhance training for judges in the area of civility. And this is really interesting because it's not a proposed training program where judges crack down on uncivil attorneys and impose sanctions. It's more about managing the courtroom in a way that is designed to diffuse, perhaps tensions between lawyers and parties, to reach practical solutions, and to avoid the need for sanctions. So Judge Stuart Rice and Judge Wendy Chang of the LA Superior Court actually put together a PowerPoint presentation for judges to use across the state in their training programs about how to do and how to accomplish the goal that I just described to you. And that is indeed attached to the civility report. But we are seeking to have the Chief Justice make this more formalized and integrate it into official judicial training at the statewide level. The next proposal 3, so this is the one that ties into ethics, and probably the one that's the most controversial, definitely the one that is the most controversial. But right now, if you read the rules of professional conduct, you will see that there isn't a requirement that attorneys be civil and act with integrity and professionalism. It's there's some of those concepts are inherent in a couple of the rules, but it's not stated explicitly. I was a legal advisor to the Rules Revision Commission, and I helped write these new rules of professional conduct, which went into effect November 1st, 2018. And the statewide ethics community is always looking at ways to continue to improve and enhance the rules of professional conduct. And this, the third recommendation, is a proposal to do just that. It would take too long to go through all the specific proposals on the specific rules. We actually have language that's drafted, but the gist of it is this. The rules would say that it's not inconsistent with your duty of zealous advocacy to be civil. That's a really powerful concept if you think about it. You can be a strong advocate and you don't need to be uncivil to do it. It's a good message for clients because many clients still believe that the way that lawyers are supposed to act is to pound the table and threaten the other side. Maybe they get that from TV shows. I'm not really sure, but indeed the rules of professional conduct, if amended in this way, would endorse the opposite proposition. The other aspect of the proposed amendments to the rules is that if you as a lawyer show essentially an egregious pattern of incivility, so not just one instance, but an egregious pattern, it could become disciplinable. And we're also talking about, however, a diversion program, which I think is really neat. So it wouldn't go immediately into a discipline system, the formal charges, but it would indeed put lawyers into a program where they could, maybe learn how to control their tempers or figure out techniques for maintaining civility in the practice of law. So I think that one is kind of neat. And the fourth one is also kind of non-controversial, but many of you probably know Pat Kelly. I think he's part of your ADR community. And when Pat Kelly was president of the State Bar, he sought to amend the rules of court. This is 2014, so that new attorneys have to take an oath of civility when they become licensed. So all attorneys since 2014 have taken this oath because the rules of court were indeed amended due to Mr. Kelly's efforts and the efforts of others. And this new proposal would require all of us who got licensed before 2014 to affirm the same oath. How would you do that? You would probably check a box on your State Bar dues statement saying that you agree to that. So that's kind of neat. The final thing that I would mention on this point is that if you track the appellate decisions on the issue of civility, you will notice some interesting trends. You will see that the appellate justices across the state are starting to more aggressively intertwine civility requirements into their appellate opinions. And again, I don't have much time, but I just will mention a couple of concepts that are set forth in these cases that I've cited to you. It's the LaSalle case where a court of appeal overturned a default judgment because they felt that the attorney who took the default essentially wasn't civil or professional enough, didn't extend requisite courtesies before taking a default judgment. And so it was overturned on that basis as well as other bases. The other case, and I believe it's the, I can't remember if it's the Carton or the Losing case right now, but one of those two has a situation where someone submits a big attorney fee bill because they're entitled to attorney's fees pursuant to the law of that case. And the court ends up reducing the bill, I think, from about $300,000 to about $90,000 for a variety of reasons. But one of the reasons is that the course of conduct of the attorney seeking the $300,000 demonstrated incivility and unprofessionalism and inability to work with opposing counsel, thereby upping the fees, and therefore the court reduced the fee award accordingly. So your fee award could be reduced due to a lack of incivility. Super interesting. So the next thing I want to talk about, and we're all interested in this, I mean, who wouldn't be interested in this, is practicing law from a remote location, or as an ADR professional, conducting ADR from a remote location. So the punchline on this is probably a little bit obvious, but I'll state it nevertheless. We all used to, certainly those of us who have been around for a while, work at our desks in the jurisdiction in which we are licensed, and we would travel to other places, but we were physically located in our area of practice. That's just not the case anymore with COVID-19. I represent lawyers again, so I'm seeing these incredible trends, which I think are positive. That's my opinion, where California lawyers will go to Florida for 2 months to be with an ailing parent, or they will, take their children for the summer to another state or even a foreign jurisdiction, and they will practice law from that foreign jurisdiction, but they're able to enhance their family time during that. There's all sorts of permutations of that, of course, but lawyers have flexibility to go other places now and still practice the law of their jurisdiction. So what do the ethics opinions say about that? There were very few ethics opinions before COVID-19, but the ABA came out with opinion, let's see, it's 498, that was March 10th, 2021, and they basically say with certain ethical safeguards in place, you can do this. And California picked up on this trend, and California now has a draft ethics opinion. It's COPRAC opinion 20-0004, and it talks about how circumstances, disaster-related circumstances, could be a tsunami or COVID-19, may force attorneys to work remotely, and what are the ethical parameters in that situation. So these ethics opinions focus on a couple of things. I actually wrote an article about this ethics opinion. I'm holding my own article here, but I summarized the key steps that these opinions say that must be taken in these remote circumstances. And a lot of them revolve around the duty of confidentiality as well as the duty to communicate with the client. So number one, ensure you have reasonable measures through your IT infrastructure to safeguard your client information. If you're going to work remotely from a laptop in another jurisdiction, maybe even internationally, how can you be assured that your client information is protected? What IT infrastructure do you have in place? Secondly, access. If you're going to be doing that, do you have full access to the client file? Obviously, it's not going to work if all the information is still in hard copy back at your office, or if for whatever reason you don't have sufficient remote access to get to everything you need to provide that level of representation. You have to make sure you don't diminish the level of communication with the client because you're working remotely. There may be a time change, you know, if you're working in France, you know, what are you talking about? I think 8 hours or so. So you have to make sure that the communication levels don't diminish. And it's really interesting too, on this point, the ethics opinions discuss obtaining a variety of contact information from your client, including emergency contact information. So it used to be, you know, you get the client's phone number and email address, but what are alternate ways that you can reach the client when the client's, you know, in California and you're in Germany? You know, this is a discussion that is recommended to have with the client at the beginning of that representation. The final thing that these opinions touch upon but don't squarely address is the unauthorized practice of law. When people started doing the remote working, for example, you're in Connecticut but practicing California law, you're only licensed in California, not Connecticut. Could Connecticut accuse you of the unauthorized practice of law? The rules, the UPL rules do differ state by state, so you always have to do a analysis of the state in which you are physically located while you are practicing California law. But generally, in the event that you're not holding yourself out as a practitioner in that state, so you are not in any way advertising yourself or even suggesting that you're a Connecticut practitioner, you probably will be largely immune from any UPL consequences. But again, that is a state-by-state analysis. So the next thing I want to mention, and this is so interesting, is trust accounting tips and avoidance of trust accounting scams. You may have seen, I'm sure you have seen, that trust accounting has become very prominent in the news and certainly the state bar, given the Tom Girardi scandals, because those are trust accounting scandals by and large. It's misappropriation of monies that are held in trust that were supposed to be held there for the benefit of the clients. We've all read the news on that. But this topic has gained a new prominence and new attention. It's interesting, when I was on the State Bar Board of Trustees of the State Bar for 4 years, this is like a decade ago, but we spent quite a bit of time looking at things like, well, should California audit the trust accounts of California attorneys? And at the time, I think 9 other states did that, including New Jersey. We didn't implement that at the time, but the State Bar now has a new task force, which is looking at how to strengthen controls on lawyer trust accounts, including amendments to the rules of professional conduct to make sure that the Girardi situation does not plague other clients of other law firms. So this is a very timely topic. So our rule of professional conduct on this is Rule 1.15. You have to hold all funds to which the client has the interest in your client trust account. This includes advance fees. Before November 1st, 2018, there was some ambiguity about where you have to hold advance fees, but now it's for sure that it has to be in trust. Interestingly, Rule 1.15, which I was involved in the discussions of it at the time that the Rules Revision Commission met, has a whole thing about what you do with flat fees as well. Flat fees are just fascinating, and there's a lot of discussion about them, but have you earned it the minute the client gives it to you, or do you have to put hours into the case in order to earn it? And the bottom line is that you should put it in trust, but you can essentially contract with the client through an informed written consent process to put the flat fee into your operating account. So there's a mechanism for that. This is just some B&P code sections regarding client trust accounting. But the one thing I would say to you is if you are a lawyer, and I think you all are, but not everybody here is in private practice, particularly if you're a private practice lawyer, keep in mind that client trust accounting is a non-delegable duty. You can't say if something goes wrong, my bookkeeper did it, or, you know, this wasn't my responsibility. It is always your responsibility. And on the bookkeeper point, it's super interesting. I mentioned how New Jersey audited client trust accounts. I spoke to New Jersey at the time that I was on the State Bar Board of Trustees, and they said actually what they learned through their audits was that a lot of lawyers weren't technically complying with the requirements, but, you know, in a minority of cases, the bookkeepers were embezzling from the client trust account. So super interesting. If the bookkeeper embezzles, that is your problem as a lawyer. And you will be ordered to replace the funds into the client trust account, as unfair as that may seem to some people. So the final thing on client trust accounting is the scams. So let me just tell you about these scams. These scams are rampant, they are sophisticated, and everybody should be keeping their eye out for them. I've handled a number of cases involving these scams. Let me just give you like one quick scenario of how the scam plays out. You are a lawyer, you are sitting at your desk. You receive an email from somebody who wants legal services pertaining to a partnership dispute. The email says that the potential client has been referred to you by your good friend down the street, Bob. Wow, this is a referral from Bob. You then call the potential client. The potential client picks up the phone. You talk about it. It's a partnership dispute. Money is owed to this client. You sign up the client. They sign an engagement letter. They give you a check for a $50,000 retainer. A week later, the purported other side to the dispute calls up and says, you know, I want to resolve this dispute. I am going to pay $500,000. I'm going to send you, the lawyer, a check to your client trust account for $500,000. And this dispute is resolved. You draft up a settlement agreement. Everybody signs the settlement agreement. You deposit the $500,000 in your trust account. Your client then demands an immediate wire transfer to the client's account. Good job, lawyer. You got my $500,000. Wire me the money. You wire the money, and 1 week later, the check is declared fraudulent. The whole thing was a fraud. There was no client. There was no other side. It was all a big scam, and your trust account is now overdrawn by $500,000. That may or may not be insurable, depending on the terms of your E&O policy. And certainly, again, as I said, you would be obligated to replace those monies. So scams are sophisticated. I mean, I've seen unbelievably sophisticated lawyers fall for these scams. And, you know, I just can't stress, it's not, you know, an email from the king of Nigeria, you know, he's going to give you money. It's much more nuanced than that. So the next topic I want to mention very quickly, just because it is a newish rule of professional conduct, is duties to prospective clients. And when I say newish, I say that because there wasn't a specific rule on duties to prospective clients in the rules of professional conduct before November 1st, 2018, though the concepts existed through you know, case law and state bar opinions prior to November 1st, 2018. And the gist of it is this. Prospective clients are a reality of anybody's practice, right? And if you are in consultation with a prospective client and you accept confidential information, you are going to owe a duty of confidentiality to that client, even if the attorney-client relationship is never consummated. So what does this mean? It means that if 2 years later the other side to that case approaches you for representation, you would be disqualified from that representation. I see this scenario come up a lot in this factual context. My client, the lawyer, consults with a prospective client. Case doesn't happen. My client, the lawyer, doesn't even enter the information into the conflict check system because it was just a conversation. 2 years later, the other side to that dispute retains the lawyer. The lawyer doesn't remember about that half-hour consultation 2 years earlier, and the conflict check doesn't catch it. The lawyer takes on the representation. The potential client from 2 years earlier says, you have my confidential information, and indeed, you cannot be adverse to me because this is the same matter in which I consulted with you, or it is substantially related to the matter that I consulted with you about. So this has huge disqualification consequences for law firms. What I would say is there are a couple of practical tips you can implement into your practice, and let me just kind of give them to you in a rapid fire way. Number one, you know, be aware of your intake procedures. I am a lawyer who largely represents lawyers. A lot of people think that I sue lawyers because they get confused. So I get a lot of calls from people who want to sue lawyers. If my legal assistant or I spoke to all these people, we could be disqualified off a whole host of cases later on when the lawyer seeks my representation. We have strict protocols that we do not accept confidential information. We tell them we cannot accept it, and we refer them out usually to a lawyer referral service. So that type of thing, having those protocols to make sure that you don't inadvertently receive confidential information that has a disqualifying effect is important. It requires training of your legal assistant. It requires you as a lawyer to be hyper diligent about who you talk to and what you talk about. The other thing is your website. Make sure that your website doesn't have a contact us form that says, send me the details of your case and we'll take a look at it. Your website should indeed say, don't send me confidential information if you contact me. A lot of lawyers have these disclaimers on the contact us form, and many lawyers actually, I'm sure everybody's seen this, when you click on their email address on their biography on their website, a pop-up comes up that says, don't send me confidential information if you're a prospective client. So those are a couple tips in that regard. So the next topic, and this may not be directly pertinent to many people on this call, but it's a fascinating topic that I advise on a lot, and I thought you'd just be interested in hearing about it. And this is the ethics of utilizing non-lawyer lead generating companies. So the practice of law has become very sophisticated. And I think, the traditional model was you are in your office and a client will approach you based on your reputation or perhaps a referral and seek your legal services. That is no longer the case. Lawyers aggressively market and seek leads for cases, especially in the consumer attorney community. And it can be pretty cutthroat out there, like who gets the good cases? Is your marketing the right marketing, or is the guy next door doing better marketing than you such that he or she is getting the good cases? So this raises the issue of, how do you generate leads for your law firm? What is the appropriate and ethical way to do that? So I just wanted to mention the two rules that deal with this. Number one, 5.4, you can't share legal fees directly or indirectly with a non-lawyer. So you will see some jurisdictions are changing that rule. In other words, they don't have 5.4 in this form any longer, but California indeed still does, as do the majority of jurisdictions. And then number 2, you have the Rule of Professional Conduct 7.2 in the advertising series saying you cannot pay a lawyer for leads unless it is a qualified lawyer referral service, which is qualified through the State Bar of California. But you can pay for advertising. What is the distinction there? So we'll talk about that. You also need to look at the Business and Professions Code. A lot of people stop their analysis, their ethics analysis with the Rules of Professional Conduct, but the State Bar Act, which is found in the Business and Professions Code, sets forth a whole lot of other standards, including a lot of advertising standards. And Business and Professions Code 6155 looks at it from the perspective of the potential lead generating company. It says that basically an individual or an entity shall not operate for the direct or indirect purpose of referring potential clients to attorneys, and no attorney shall accept a referral of such clients unless, again, the company making the referral is a qualified lawyer referral service. However, Business and Professions Code 6155H, which is down there, says that while companies can't exist for the purposes of making referrals that the lawyers pay for, lawyers can engage in joint marketing campaigns. And the practical effect, I've seen a lot of this, the practical effect of this is that advertising companies for lawyers exist. There's a lot of them, and they will aggregate their clients, and they will do these joint marketing campaigns. What is the proper way to do it? Well, the rule tells us. It says that the marketing campaigns need to identify the advertising attorneys or law firms whom the consumer of legal services may select and initiate contact with. So turning to my next slide, I think I'm going to skip this one because there's this just kind of reiterates my points. But there's a recent published decision about this whole issue of lawyer referral services, what qualifies as a lawyer referral service, and whether, again, it is appropriate to be generating leads for lawyers if you're not a lawyer referral services. So this is the Jackson v. Legal Match case. You may have followed it. It's been in the Daily Journal. There was a lot of press about it. But basically, Dorian Jackson failed to pay for his legal match subscription, and they pursued him, and he cross-complained, saying that Legal Match was operating in violation of what we just looked at, Business and Professions Code 6155, and they're an illegal lawyer referral service, and therefore the contract he has with them is void and unenforceable. The punchline is that the Court of Appeal ultimately agreed with that, and this was kind of a blow to companies like Legal Match. Companies like Legal Match are and have been given an opportunity to come into compliance with 6155 by essentially making an application to become a certified lawyer referral service. But what's most interesting about this case, the Jackson case, is that it talks about the legislative rationale behind Business and Professions Code 6155. And specifically, it says that, years ago, there were category of people called runners and cappers. You probably heard that before. And they've also been referred to as ambulance chasers. And what the legislature found at the time, as reflected in this published opinion, the Jackson case, is ambulance chasers often do not have the best interests of the clients at heart and would use overreaching and high-pressure tactics to acquire clients. So that's why Business and Professions Code 6155 says you, as a non-lawyer person or entity, can't be in the business of just generating leads for lawyers, because you could fall into this dangerous category of ambulance chaser or runner and capper, thereby, inappropriately pressuring people into retaining a lawyer. So that's the landscape. With that being said, lawyers have found a lot of creative ways to do advertising and to effectively get leads without violation of these rules, including the joint advertising that I discussed a second ago. So we're going to go through this very quickly, but I did want to mention fee splitting with lawyers. So lawyer-to-lawyer fee splitting. This is big business too. Anybody who is in the consumer attorney community in particular can tell you and testify to the fact that there are wonderful networks of consumer attorneys who refer cases to one another, pair up on cases, create consortiums or joint ventures that involve sometimes complex fee-sharing arrangements. So what does the ethical rules say about this? So you take a look at California Rule of Professional 1.5.1, again, enacted November 1st, 2018, and it is slightly different than the predecessor rule. The standards changed for fee sharing in California among lawyers November 1st, 2018. So what does the new rule say? Well, the first thing it says is that you can make a referral and get a referral fee even if you don't work on the case. I think people know that, but interestingly, that's not the rule in the majority of jurisdictions across the United States. Many jurisdictions require, in order for you to get the referral fee, for you to provide value or services on the case. So you may have heard in other jurisdictions, the referring lawyer will show up with his or her briefcase at a deposition and sit there for 8 hours in order to justify the receipt of a referral fee. So that's kind of interesting. So in terms of the requirements of 1.5.1, essentially it's this. I have a whole slide on it, but to give you the Heather Rosing overview, you need a writing with the other lawyer up front. Not just we'll split fees, but here's exactly what it is, here's how we're going to do it. You then need a writing with the client up front, and you need the client's consent, informed written consent, to the fee splitting or the fee sharing or the referral fee with the other lawyer. It should say who the other lawyer is, here's the amount, and you, the client, agree to it. Many lawyers, in my experience, don't comply with these requirements, and it causes huge disputes at the end of the case if there's a big settlement or a verdict or a judgment. So documenting up front is a protective measure for yourself, and of course, it's the good, right, and fair thing to do for the client. Keep in mind that if you don't have a fee-sharing arrangement in compliance with the rule and you provide services on a case, you still theoretically can get paid for your services through a theory of quantum meruit, and I gave you a case here that talks about that. So the next thing in our rapid fire ethics lesson this morning is working with clients with diminished capacity. I've taught this program probably 20 times because I give a lot of CLEs for probate attorneys and trust and estate attorneys on a pro bono basis. And here's the long and short of this particular topic. California does not have a rule of professional conduct on how to work with clients with diminished capacity. We, the Rules Revision Commission, drafted one, but it was complex and nuanced because we were constrained by the confidentiality provisions in the Business and Professions Code. The Supreme Court did not adopt the recommendation to implement a rule of professional conduct in California. for clients with diminished capacity. So we just don't have it. But the ABA model rules does have a rule 1.14. So California, realizing everybody else has a rule, we don't have a rule. Actually, just recently, last November, came out with a new State Bar Ethics Opinion, 2021-2007, talking about the ethics of dealing with clients with diminished capacity. It's excellent that the State Bar Ethics Committee, which is known as COPRAC, did this because it provides wonderful guidance. I commend them for coming out with this opinion. But the gist of that opinion is as follows. When working with a client with diminished capacity or potential diminished capacity in the future, there are a couple of things to keep in mind. Number one, you need to do whatever you need to do to maintain as normal of an attorney-client relationship as possible. Just because the client may have declining capacity doesn't mean they aren't entitled to the full panoply of protections and communications inherent in the attorney-client relationship in California. Obviously, this becomes difficult if capacity is significantly diminished. I teach a program for I've done it for maybe 10 years to court-appointed attorneys. These are attorneys who are appointed to represent usually a proposed conservatee and protect their interests in a process where a conservatorship may be imposed. And sometimes these clients are nonverbal, and sometimes they're, catatonic. So how do you maintain that normal attorney-client relationship? It becomes very difficult. The other thing is you are required to maintain the competences of the diminished client. It's interesting because the ABA Rule 1.14 allows you, if the client is going to be harmed, to take protective action on behalf of the client, even potentially using confidential information obtained from that client. California does not allow that because in Business and Professions Code 6068E, we owe the highest duty of confidentiality to every client, including clients with diminished capacity, and that is even at our own peril. Those are the words found in Business and Professions Code 6068E. So you cannot take the confidential information and go out and try to find doctors or family members or friends of the person and take protective action for that person. However, you could do that with their consent. Sometimes clients will consent to that. There's a couple of ways to get consent. You can get advance consent in your engagement letter. And so your engagement letter would say, in the event that your capacity diminishes, you give us permission to consult with this doctor, this family member, whatever it may be. You can also obtain that consent at the time when the capacity is diminishing, which may be midway through the attorney-client relationship. So it's a very interesting landscape working with clients with diminished capacity. Mainly, in my experience, it's trust and estates attorneys and probate attorneys, again, who deal with this. It's interesting. I teach a special ethics course for IP attorneys, and I had a whole section on clients with diminished capacity, and it turns out IP attorneys are not very interested in this topic. So it's largely confined my larger course to trust and estate attorneys and probate attorneys. Okay, we have just a couple of final minutes here because I did want to take time for questions. I indicated that I'd be available for that. But let's talk about my one of my favorite topics. And I mentioned to you before that that the landscape for the practice of law is changing in some very significant ways. And if we're not paying attention to this, whether you're an ADR professional, a judge, a lawyer, then you're behind the curve. So I'm going to give you some information, and I urge you to keep up to speed on these developments because I think it's the way that you define yourself as a cutting-edge practitioner, and you can keep up with the trends as they emerge. I spoke earlier about fee sharing. I talked about it in two different contexts. I talked about it in the context with non-lawyers, and I went through all those rules with you. Can you fee share with a non-lawyer? Under what circumstances? And as you saw, California has very strict rules saying you can't do that. There are some exceptions to it, but generally you can't do it. And then we looked at the fee sharing rules that you can do lawyer to lawyer. So we looked at that whole concept. The State Bar of California has become interested, rightly so, and these discussions started when I was on the Board of Trustees, which I think was like 2010 through 2014 or something like that. But those discussions also preceded my involvement on the Board of Trustees, and certainly have occurred in an even more robust form since my work on the Board of Trustees. But the gist of it is this: how can we adjust the practice of law in order to enhance access to justice? That's the overriding concept. It's not how can we help the lawyers make more money? It's how can we help people obtain legal representation and access to justice? You've heard of the justice gap. The justice gap in California is a very real and potent thing. You look at the statistics of how many people are self-represented in the course of family law cases, how many people are self-represented in unlawful detainer cases, how many people are unrepresented in, consumer debt cases. The list goes on, and there are, as I'm sure everybody has seen and can appreciate, significant problems with the self-represented litigant, also known as an SRL, navigating the system of justice, because it's complex and you aren't cut breaks at the end of the day. You need to comply with the, Code of Civil Procedure or whatever the rules may be that govern the forum in which you have your legal matter. So how can we help these people obtain access to justice? And it is that fundamental concept that led to this discussion about the evolution of alternate business structures in the law. So going back to the State Bar of California, the State Bar set up in its most recent iteration a task force called ADLS, and you've probably heard of ADLS, and now I'm going to struggle with what the acronym stands for, but it's something to the effect of, enhancing technology in the law in order to enhance access to legal services. Obviously, that's not the exact, doesn't play in exactly with the acronym, but that's the gist of it. And the California Lawyers Association had involvement with ADLS. A couple of my friends and, one of my law partners participated in ADLS. And ADLS has since continued on even in a newer iteration. And you may have heard discussions about the sandbox. And so ADLS considered a sandbox of ideas, essentially, to enhance access to justice. And those are in the vein of, those ideas are all in the vein of alternate business structures, which include allowing non-lawyers to assist in closing the justice gap. Other states have had task forces and movements similar to the California ADLS task force and movement. And some of the other states, as we'll see on the next slide, have actually implemented changes to the rules of professional conduct and the regulatory framework to allow this to occur. California has not done that yet. These discussions are ongoing, and they are controversial if you followed them. But nevertheless, it's all part of what I believe is a rapidly changing landscape, and it's important to keep up to speed. So let me talk a little bit about alternate business structures with that background. So here we talked about Rule 5.4. You already went into detail that I went into detail with that about you earlier on. And then we look at the states that have implemented rules that are different than the 5.4 rule. Utah, Arizona, and Washington authorize alternate business structures subject to regulation. What does this mean? It allows, in certain forms, non-lawyer ownership of law firms. Non-lawyer ownership of law firms. It also allows, in certain forms, the sharing of legal fees with non-lawyers. It also allows, in certain forms, people who do not have a law license to provide limited legal services absent supervision of a licensed practitioner in that jurisdiction. Now, the Arizona rules are fascinating, and I give a whole talk about the Arizona rules, and we don't know exactly how they're going to play out because they're brand new, but I will tell you they have attracted a lot of attention, particularly in the consumer attorney community, about how a law firm can be opened up in Arizona with a non-law partner, perhaps somebody who can infuse cash into the law operation in return for what is now allowed in Arizona, which is fee sharing with that non-lawyer partner. Really, really interesting. So looking at this point about legal paraprofessionals, let me make a couple of follow-up points on that. There have been ways that non-lawyers can provide limited legal services, usually but not always under the supervision of an attorney, for decades. California has a category of non-legal professional called a document preparer. There are certain types of immigration consultants who are not lawyers who can provide legal services. And every state has their subset of non-lawyers who can provide limited legal services. But it's very constrained. And currently in California, it's very constrained. So the idea is, and I think this is, I'm going to give you an example of how it played out in another state, is to allow paraprofessionals or non-lawyers, some may say paralegals, to obtain a certain amount of training in a very specific subject matter, require that they be bonded or insured, and then clients can hire them directly without the supervision of a lawyer to do certain tasks. So Washington State did this. They started up what's called the Triple LT program, limited licensed legal technicians, I think is the acronym. I'm not very good at acronyms, but it's essentially, paralegal or paraprofessional types who went through the training and the bonding that I just discussed. And it was initially launched in a couple of narrow practice areas, including family law. Now, Washington State ultimately sunsetted that program because it was so expensive to run, and only, I think, 40 people had signed up as of that point in time. But the concept was interesting, and some may say the concept was solid because, again, over 80% of family law litigants in California don't have representation. Is this a way for them to be able to pay $50 an hour, $100 an hour to get competent advice from a paraprofessional when they would be unable to afford a lawyer's services for that same type of advice? So California, in this ADL sandbox structure that I've described to you, has heavily considered the paraprofessional idea. Now, I'll disclose this. It may be controversial, but I like the idea. I think it's a good idea. And I wrote an article in the Daily Journal about why I think it's a good idea to explore it. If anybody's interested in hearing why it's a good idea, let me know, and I'll email you my article from the Daily Journal. But there has been great opposition from the profession. Many people, I don't know the exact number of public comments to the State Bar, but certainly hundreds have come out against it. People say that this could be an inappropriate protective measure by lawyers who don't want competition in their industry. But other people have, very legitimate concerns, such as the quality of services. Can you really rely upon somebody who hasn't gone through 3 years of formal legal training at a law school to guide you through what may be a complex family law situation, for example? So pros and cons, supporters and adamant opposers are on all sides of this equation. With that, I only have 7 minutes left, and I was going to reserve 10 minutes in the event I had it for questions. I don't have 10 minutes, but I would like to give you this final opportunity in the remaining 7 minutes for any questions that you may have. And I'll put this out there because this is such a great group. I recognize many of you in this really esteemed group here. You can ask me any ethics question. It doesn't have to be constrained to my topics. So go ahead and I'll take any questions that you may have for me in the ethics, risk management, legal malpractice, or judicial ethics arena. That's my knowledge. I'm ready.
Heather, this was just terrific. Thank you so much. While as mediators, we don't practice law, we deal with lawyers all the time, and understanding the ethical parameters, the ethical constraints under which they operate helps to explain a lot of lawyer conduct which we might see, and also helps us deal with a lot of these situations, whether in conservatorship matters, disputes between lawyers over attorneys' fees, and all of those other things. Do you have specific tips for mediators on perhaps how to raise some of these ethical issues, whether it pertains to civility or Other things, we do sometimes see lawyers behaving, shall we say, curiously. How might we utilize some of these ethical tools in trying to get better results for their clients?
Yeah, that's an excellent question. I mean, I think I will say this, you know, I assume we're talking about the two different basic ADR concepts. You have mediation and arbitration. I mean, certainly in the context of arbitration, you know, the civility rules, I think, come heavily into play. And I would say as an arbitrator, I'm not an arbitrator, but if I was an arbitrator, you know, tips and techniques that are utilized well, not utilized, but described in our civility report absolutely can be utilized. They're described for superior court judges in our civility report, can absolutely be utilized in the arbitration context. So I would also say, if you want to see our civility report, email me. Now, you have to have the ability to accept a 300-page PDF, by the way, if you email me. But the report itself, just to give you some comfort that you don't have to read 300 pages, is only about 20 pages. The rest are attachments. But I think that you have real tools at your disposal in the arbitration context related to civility. You are dealing with attorneys' fees awards, potentially, if it's allowed by contract or statute. And what kind of behavior do you see from the lawyers? And, you know, can you give them warnings up front that if certain behavior continues, that you may be inclined to follow the reasoning set forth in that opinion that I described to you, where the trial court reduced the attorney's fees award due to incivility by the attorney claiming that award. So that is one tip I would offer to you. You know, the other thing, it is interesting. A lot of lawyers don't appreciate the rules of professional conduct. And I'm sure, particularly in the mediation context, you'll be hearing things from lawyers who you're like, that can't be right. You know, that can't be allowed. This must be in violation of a rule. What do you do about that? And I very much respect and appreciate your profession. I know how delicate you have to be in the handling of lawyers. You can't openly criticize them, certainly in front of their clients, because that would have an adverse effect on your ability to get a resolution of the case. But nevertheless, I think gentle reminders about the ethical standards to the lawyers is appreciated, you know, especially if you're doing them a favor. You know, for example, certain things may be proposed with regard to fee sharing or fee sharing with a non-lawyer. You may hear this come up in the context of a mediation, or, you know, a conflict of interest concern may come up. You know, gently pointing out the rules of professional conduct, or gently pointing out that they may want to consult with somebody in the ethics arena may be ultimately a service to them. You know, one thing I will say is that many lawyers have E&O insurance, errors and omissions insurance, colloquially referred to as legal malpractice insurance, and the carriers offer tremendous risk management resources. So, you know, hey, you know, you may want to check there may be risk management resources available through your carrier. Or, hey, the State Bar of California has an ethics hotline. It's pretty good, and it's free. You know, and then there's all sorts of people like me who can also provide kind of on-the-spot advice to lawyers who may suffer from these dilemmas. But it is a perilous landscape for lawyers out there. I will tell you this, and, you know, I see, again, my good friend Laura Frankel, who's certainly a legal malpractice expert in many different ways. She and I have worked together for decades, and it's good to see you, Laura. The lawyers are being bombarded with legal malpractice claims, claims of ethics violations, state bar complaints in a way that I haven't seen before. It seems like the profession is becoming more and more imperiled. I have clients who are resigning from the practice of law because they find the landscape just too complex and perilous. And, you know, malpractice and premiums are very expensive, even if you don't have a claim. So it's a difficult environment out there. To the extent that you can, you know, help the lawyers with resources that will mitigate their risk, I think you're doing them a favor as a mediator in particular.
Thank you so much. I wish we had time for more questions. We're at the top of the hour. As they say on radio, it's a hard break. We just got to leave. Respect everybody's obligations to get on their next Zoom call or other work. Life seems to be at the top and the bottom of the hour. So Heather, thank you so much. This was a wonderful, incredible presentation. You covered a lot of topics at very high speed. I hope that people are able to contribute to the San Diego Food Bank That's www.sandiegofoodbank.org, www.sandiegofoodbank.org. And if people want to reach you at Klinedinst PC, you were kind enough to post your email in the chat. Heather Rosing, thank you so much for supporting the Will Work for Food project, appearing on the New Possibilities Hour. With that, we are complete.
Thank you so much.